Testing, testing, 1, 2, 3. Okay, guys, let me know if you can hear me loud and clear. Testing, testing. Let me know if you can hear me loud and clear. So we have a really good show tonight. And loud and clear. Thank you, Oli. Thank you, thank you, thank you. Hi, Catalia, Southern Belle. I don't see her here yet. TJ, Barb, everybody. So welcome Monday night. We do have a guest coming on a little bit later on in the show. LA Pink, she's coming back on with her attorney. So it's going to be a really good show tonight. Going to start off talking about Fulton County crisis, the YSL trial. Brian Steele, the attorney for Young Thug, got put in jail for contempt. But we have to, that's kind of foul. We also got to talk about, what is her name? Shalitha Robertson. She is a former Atlanta attorney and police officer out of Fulton County, and she was sentenced to 7 years for stealing, was it $20 million or something like that in PPP loans, probably 15 or 20 million. And then, of course, Russia. Putin gave the green light to have their warships docked in Cuba, but apparently he's saying there's no missiles on the ships. So that's later in the show. That's late. That's going to be probably the last 15 minutes, because what's going to take up most of the show is the YSL trial and Fani Willis, because we got to bring her down and all the corrupt people out of Fulton County. So please like. Oh, and of course we got to talk about Trump news as well. But we're going to start with Fulton County. All right, guys, like the show, share the show. Hello to everybody on X. Please repost the show on X. If you have a question or a comment, please send it via super chat, because it's easy for me to catch it. And let me bring up the judge. Hi. Oh, you still got your suit on.
Yeah, I had to go to court today myself.
You ain't get none of my texts?
What's that?
You didn't get none of my texts?
No, I didn't. I've been sitting here right where I am right now trying to get the stuff. So what I wound up doing was I used my iPad as a hotspot, got in through that. I had to be ingenious. Anyway, it's more than the woman being a cop in Fulton County.
I didn't want to go into that right now.
No, I know, but just one little thing. So when you're doing a research, as you always do, sitting back there, find out what what other position she had besides being an attorney and a former cop. It's interesting. It might have a great deal to do with our current target's circumstances, meaning Miss Fani.
Oh, yeah. Definitely. And I have the actual United States docket.
They seemed like there are little misappropriation of funds and embezzlement acts down there. I don't know. Maybe it's a hobby.
Yeah, well, maybe, but we're going to get into that.
Ooh-wee.
We're going to get to that when LA Pink come on, and that's going to be in about 30 minutes. We are running a little bit late, so I would say in 40 minutes. So I'm going to push it to 10, because I told her 9:45, so I'm going to push it to 10 p.m. Eastern. Maybe before then, because I want, of course, the YSL trial. We haven't been following it as much on when we do the shows here. However, a lot of breaking stuff that happened today, and I want to start off with one of the witnesses who was arrested last week in contempt because he wanted to plead the fifth. And let me see if I can. Let me share this. So this is Kenneth Copeland, aka Woody. So he was arrested last week because he didn't want to answer the questions and wanted to plead a fifth. So they held him in contempt. And this is him. I believe this is today. Is this today? June 10th. Yes, this was today. You know, he has on his jumpsuit, and he's sitting in front of the courts now. Now he was allowed to go home, but this wasn't a clip that I wanted, but it doesn't matter.
You got any backup clips on what the alleged circumstances are?
Yeah, I did, and darn it, I forgot to copy and paste on my notes here. So let me just go through this one here because she usually has that. Oh no, I think I saved it in my bookmark here. Just give me a second. Not this one. Not that one. Nope, wasn't that one. Wasn't even that one. All right, let me look. Oh no, I know where it was at. Jeez. I forgot to put this link in my notes. Sorry about that. All right.
Do we have music?
You'd be kidding me. I can't see the thing. Okay, you can see it. You can see.
I see something that looks like a video in the middle of my small
Mr.
screen.
Copeland here. So go ahead, Miss Hilton.
Thank you, Your Honor. Mr. Copeland, good afternoon. Good afternoon.
I got to say it back.
You haven't said anything yet. On Friday, when we left, I asked you how old you are. You said that you were grown. Can you please tell me how old you are?
Say that again.
Sure. Can you please tell the jury how old you are in numbers?
32.
And when is your birthday?
Say that again.
When is your birthday? I'm sorry. When is your birthday?
Next month.
Is that July?
I think so.
Okay. And were you born on July 25th?
I guess.
Okay. Are you from Atlanta?
I'm from Canterville.
Okay. Is that a section of the city in Atlanta?
I guess.
You guess. All right. And did you grow up in Mechanicsville?
For sure.
Did you say for sure? All right. And when you grew up, do you have siblings?
Huh?
Do you have brothers and sisters?
Yeah.
All right. And when you were younger, did you live with all of your brothers and sisters?
Overruled, sir.
Yeah.
Okay. I want to specifically talk about your brothers. How many brothers do you have?
Overruled, sir.
More than one.
Okay. How many?
I think 3.
All right. And what are your 3 brothers' names?
Overruled, sir.
Trey Nato boss.
Say that one more time. You said it's fast.
Nato Trey's boss.
Nato, Trez, and Boss. Okay. Nato, what's Nato's given name? Or you just give me the first name.
I just did.
Nato?
Yeah.
Okay. Trez, what's Trez's first name?
Trey's.
Is Trez's first name Ron Trez?
I guess.
All right. And Nato, is that Rodney?
I guess.
Okay, and then what's the third nickname you gave me?
Boss.
Is Boss Rodriguez?
I guess.
All right. And when you were younger, did you go to school?
Yes.
Where did you attend school?
I don't know. I went to a lot of different schools.
Okay, what are all the schools you went to?
I don't recall all of them.
Or just tell me some of them.
I only know one. Slater.
Slater, is that elementary school or middle school?
Elementary.
Why you don't remember what middle school you went to? Did you go to middle school?
I think I did.
How long did you go to? Did you finish middle school?
Relevance. Overruled.
Yeah, I think.
Okay. Did you go to high school at all?
Yeah.
All right. When you went to high school, did you go to Southside?
Yeah.
Yeah.
Overruled, sir.
Did you graduate from high school?
No.
All right. Do you remember what year you left high school?
No.
All right. After high school, did you work?
No.
What did you do after high school if you weren't working?
Say that again.
Did you do anything? If you weren't working, what were you doing?
I don't recall.
Okay. Are you married?
Nope.
Are you in a relationship?
Nope.
Right. Do you have children?
You know that.
Okay. I do, but the jury doesn't. Do you have children?
Yep.
All right. How many?
More than one.
All right. Do you have more than 3?
I might. Ain't no telling.
Okay. That's perfect. That's fair. Do you have 2 that you know of?
Yeah.
All right. And how old are your 2 children?
The same age.
What's that?
I don't know. Y'all been having me in jail so long. I can't recall.
Okay. Were you in jail on Friday? Prior to?
Yeah, I was in jail Friday.
Were you in jail on Thursday?
Thursday ain't came yet.
No, last Thursday.
I felt like it.
All right. When you weren't in jail last Thursday, although you felt like it, how old were your children?
I don't know their ages.
Okay.
So I want to pause there.
How is he a defendant?
I didn't get clarity on that. He is the witness for the prosecutor. His name is Kenneth Copeland. Little Woody continued to testify on Monday afternoon after previously pleading a 5th last week during a Young Thug YSL trial. Little Woody appeared irritated during the questioning as the state inquired about his background and criminal record.
I'm trying to figure this out. Who called him?
The prosecutor.
Okay, so it's a prosecution witness who is a hostile witness. The whole problem could have been resolved by simply requesting that the court declare this to be a hostile witness. And then you can cross-examine the person and ask leading or direct questions rather than non-leading questions that are ordinarily the case if you call a witness. You cannot lead on direct, but when it's a hostile witness, you can lead as though you're cross-examining somebody. That would have solved this whole thing. I take it he's not a defendant.
No, but he was part of the YSL, I guess, crew or something.
Well, then why is he in jail for taking the 5th?
Yeah, so it says after it seems that a witness in a Young Thug trial with use immunity was reluctantly going to answer questions in court since that testimony could not be used against him, he suddenly reversed.
Well, hold on. Use immunity means it's limited. It's not a blanket immunity. So he might need to be appointed counsel if he does not have one before we get into locking him up for contempt on use immunity. The judge has been very tolerant of the prosecution, who's tramped all over the rules again and again and again, been insolent, been hostile, disrespectful, and everything else. This man is asserting the 5th. So I don't know all of the circumstances attendant upon this situation,
I'm
but
not gonna play the whole video because it's
no,
20.
I don't want to hear the whole video. But I
But I'm
mean,
gonna
if
read
he's a
you the
witness,
information. Yeah, he's a witness for the defense because the defense kept saying, objection or whatever relevant.
no, he's not a witness for the defense. He sounds like he's a hostile witness for the state, and he doesn't want to testify. And he's taking the Fifth Amendment. So what he wants before he testifies is absolute immunity, which in case if he had an attorney, what would result is he would not stonewall answering the prosecution's questions, but if anything, he would volunteer, because anything he said on the witness stand could not be used against him under that qualified immunity. And the more he stated, the more immunity he gets himself. So what's going on is a nebulous thing, form of limited immunity, where what you say that is useful to the prosecution during that particular case cannot be used against a witness, but that's not saying that it could not lead to other material or expose or develop or incriminate, which could be very bad for the witness. That's like what Fani did. She didn't confess so much to some crimes, though she did, but she incriminated herself by indicating that she may have, or that there was at least probable cause to believe that she had committed various and sundry other criminal offenses.
Mhm.
So this gets a little nebulous. I'm concerned about where is the guy's attorney and who is this objecting. He sounds like he's one of the defense lawyers who is doing a proper job on behalf of whatever client he represents.
I see what you're saying. Because the judge, it says here, the judge did say to him, I just want to make sure that you understand, if you don't testify, then as the judge in this case, have several remedies. One of those is that I can hold you in contempt and jail you because the way that you get out of that contempt is to just testify. So and
If I was the witness in question, I'd hold out for absolute immunity, transactional immunity rather than testimonial immunity.
Well, do you think that he's probably that ignorant, or you think he's playing ignorant?
He's not playing ignorant. He's doing what the Fifth Amendment allows him to do. And I think the judge is getting questionable here. But this is something that has come up over and over again in the last 30, 40, 50 years, is what does immunity mean? Qualified immunity. Well, what? In other words, let's say that you testify to something and it leads to other information. Some immunities would allow what the testimony led to be used, if not the testimony directly.
Mhm.
Like he and I went into the bank together and so and so and so. So he and I went into the bank couldn't be used, meaning you couldn't go in, but it might have led to some other information that would implicate you in the bank robbery. See, so it's complicated. It's nothing simple. And
Right.
it's got to do with the law. And I think from the length of time this trial has gone on and what we have been looking at, I imagine His Honor is quite frustrated by the whole thing. And he wants to get things moved, but he's got an impediment right here, which is the state hasn't granted full immunity
Mhm.
to the witness that they've called, who they need to get declared as a hostile witness, which would clear a lot of this up.
All right. So with that said, all right, I want to move on to
So where did the lawyer get found in contempt?
right. So
By the way, it's a piss poor defense lawyer who's been practicing for a while, who's not been threatened with or found in contempt for vigorously defending his client. Amongst the trial bar in my generation, it's like you're not very good if you haven't been found in contempt. Just about everybody of note has at one time or another been locked up for contempt, held in contempt and fined, or threatened with contempt for vigorously defending a client.
Well, I want to read this first and then I'm going to play the video. Fani Willis prosecutor's private meeting with judge revealed. So a private meeting between Fulton County District Attorney Fani Willis' office and the judge overseeing the Young Slime Life trial was revealed after one of the defense attorneys disclosed that the parties had met with a witness without telling the defendant and their lawyers. And okay, blah 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 blah.
There needs to be, generally under ethical considerations, an announcement and a disclosure that there's an ex parte meeting that has occurred. Generally, these ex parte notices occur when a client has done something unethical that the attorney cannot abide by without implicating himself or herself in the unethical conduct. So they have an ex parte conference with the judge and explain to the judge in confidence what the client has done wrong. And the reason it's ex parte where everybody else is excluded is so the prosecution doesn't find out what it is, and the lawyer satisfies his responsibility to being honest with the court. See, lawyers do not have any responsibility to lie for a client or assist a client, knowingly assist a client in lying. Mm-hmm. So quite often, I'd had defense lawyers would come up and ask to speak to the court in confidence. That's called ex parte, meaning just one person, and explain that they can't, in good conscience, call the defendant mm-hmm. and question the defendant in a fashion that would perpetrate a falsehood. So what usually happens is the court gives the defense counsel the opportunity to simply call the witness, ask him if he wishes to take the stand. The witness, his client, takes the stand. I swear the client in, and then I permit the defense lawyer to request that the witness be allowed, that his client be allowed to give a narrative testimony without him having to examine the witness and ask questions, so he does not implement himself in the wrongdoing. So he'll just say, you have something to tell the court you want, or then the jury, you wish to speak to them about this case. Tell them your story. And I would expressly forbid the prosecution from mentioning that, so it did not violate, one, the attorney-client privilege of confidentiality. Two, it did not implicate the defense lawyer in perpetrating the deceit on the judge or the court and the jury. And three, it did not violate his rights against self-incrimination.
So let me
there you go.
It says Brian Still, the attorney of Young Thug, said the Fulton County prosecutor, Andrea Love, and Judge Glanville told the witness, Little Woody, whose real name is Kenny Copeland, that he could be held in jail for the remainder of the trial and that those conditions could be true on all 28 defendants in the case. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. This is what Steele said to the judge.
It's not unusual. It's happened a lot of times in the past, federal and state, where somebody is held in jail for contempt for refusing to testify when an immunity has been granted. That is your right, but you can be confined. And there's what you call a material witness situation, which is if a witness is material or important to develop aspects of the case on one side or the other, you can arrest the defendant and require, amongst other things, that the defendant post a bond to appear to testify. And if they refuse to testify after being granted immunity, which is their right, you can hold them held in contempt until the matter is over.
Okay. Well, it says still revealed that the judge and the DA office met with Copeland and Copeland's counsel early in the day, and that none of the defense team, to my knowledge, was aware that this was going on.
Well, that just might be to that one specific issue, and certain things that might properly be held in confidence. I don't know because I wasn't there and I don't have that information.
Right. So it went on to say the revelations angered Glanville, Judge Glanville, who said the meeting was ex parte, which allows the court to meet with one party without requiring all parties to be present.
Now, the court has to justify that on the record.
Okay. Judge Glanville demanded to know how Steele found out about the meeting, to which the defense lawyer replied, "I'm not going to answer your question. The quip, Q-U-I-P, quip, the quip only further angered the judge, who said, if you don't tell me how you got this information, then you and I are going to have some problems. It's disturbing how you have somehow surreptitiously gotten information in regards to the court's private ex parte conversation with a party."
Yeah, well, that's the same thing about the Supreme Court's draft on that Roe v. Wade decision being released. See, nothing came out of that. It's inappropriate, but the lawyer did what he had to do. So, yeah, if he got jailed for contempt, more power to him. I respect that. Sometimes you got to do what you got to do. I did 5 days after I had retired because I was defending a woman against a jackass down at the local juvenile court, which is a kangaroo operation. The person wasn't an elected judge. He was appointed by a judge who dropped out of the 6th grade and was not permitted to hear cases. So basically, I did 5 days because I was in contempt for insisting on this woman's rights being protected. And ultimately, before I wound up serving the 5 days, I won the case against the woman. Some clown had declared that she was the mother of his child. From the last time he saw her, the child would have been 30-some years old. Matter of fact, she had not had a child by this guy, and he had never paid child support. The warrant was rubber stamped. Nobody signed it. It was supposed to be subject to immediate dismissal, and the asshole involved, his name's Harold Horn, had a golf tee time he wanted to go to, so he didn't have an opportunity or time to recall the warrant. And contrary to a federal court order, they didn't record the proceedings because the juvenile court was under that.
I want to stay on track here.
So I'm just saying, you have to do what you have to do. Sometimes it requires personal sacrifice. That's the point. So I get the lawyer's thing. He got information. It should have been brought out. There should have been a disclosure. Georgia law may not require it, but Tennessee law and law in other places certainly requires that the judge give notice that there was an ex parte communication and what it was about. That's in the federal system as well. In other words, you have this, you have to let everybody know, and you have to state your reasons why it was private without the other side being allowed to be present.
All right, so I want to play this clip.
I can't hear it. I can't hear anything. Dana, can't hear a thing.
Oh, I know. Give me a minute. Can you hear that?
Yes.
He's right behind you.
Sorry, I have a motion that I need to make outside the presence of Mr. Copeland.
All right, you can make it right now. Is he out?
Let me know when you get down to the.
Is Mr. Copeland out?
No, he's a fan.
Okay, good. All right.
Yeah, come on down. Don't come in the court. Come when you get back.
Thank you.
Go ahead.
The way I understand my constitutional obligations pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told based upon information and belief that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland and this court, were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never.
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to answer you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia.
Ever wondered why you should get an LLC with a third party when you can do it?
Damn commercial.
38, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
and you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte
Why?
with a party,
Why?
state of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele,
I'm
I
doing
still
what
want to
everybody
know,
should
how
do.
did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this
I
information
don't
was
want to
come
be
from.
held in contempt.
Well,
I'm not
then-
answering that question. That's attorney-client privilege information. I am not answering that
Attorney-client privilege, unless you were in my chambers, that's the
I'm-
only way you can figure out.
I am
I
telling
tell you what, I'm going to give you 5 minutes. If you don't tell me
You don't have to. I'm
if
gonna
you don't tell me
continue.
who it is, I'm going to put you.
But let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information
I don't
supposedly
answer
from
that
my
question.
chambers? Did somebody tell you?
I'm not. You should have told me.
Who?
Well, I don't need it. I want to continue. This is what I was told. Mr. Copeland made statements that he admitted to killing Dr. Thomas and was. Don't take my notes. No. I have a.
He's right behind you.
Sorry.
Work product of the attorney. Very good. Outstanding,
You can
young
make it right
man.
now. Is he out?
Let me know when you get down to the.
Outstanding.
Mr. Copeland.
He's a fan.
Okay, good. All right.
Yeah, come on now. Don't come in the court. We'll come and get you back. All right.
Thank you.
Now, the appropriate way to
No, go
handle this is to tell the lawyer there will be
Dwayne, I
a
understand
hearing
my
after the proceedings where he will have to show cause not to be held in contempt, not to interrupt the proceedings in front of the jury, which is exactly what the judge did, which is a bad, dumb move. Not saying that all of us don't occasionally do that from time to time, but this was a dumb move where he has interrupted the jury trial to do this instead of saying, let it be put down that we're having a show cause hearing after these proceedings where counsel will have to show cause why he should not be held in contempt for failure to divulge the information demanded by the court.
All right.
That's the way it should have been handled, but it wasn't.
What is it? 5 more minutes. Because I kind of
I
want.
know, but it from this point on, everything that's done is way wrong.
Right.
And it was not appropriately handled. Like I said, if you've got a thing like this and you're the judge, what your remedy is to say, let the record reflect that the defendant's attorney, name him whoever he is, will be required to show cause why he should not be held in contempt after these proceedings are completed. That keeps the proceedings from being interrupted and the rights of the defendant represented by the attorney in question from not being compromised. So he's going to lock the lawyer up. So what's he going to do about the defense of the client he represents? See, that will compromise that client in front of the jury. And the judge is in charge of that. Way wrong.
Right. So I want to finish playing it.
At this point, everything that happens after this is wrong. There's no excuse.
Right. I think for dramatic purposes, LA Pink, I see you. Just give me a minute. And then I want to play.
And let me explain what I meant by that very briefly. You're 6 floors up in an office building and you step out the window. Once you step out that window, there's 6 floors down. There's not a damn thing you can do about whatever you say, think between floor 6 and the ground, which is what's going to happen when you go splat. So in other words, everything from this point on is you stepped out the window. There's a long way to the ground.
Constitutional obligations. Pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record,
You
and if
played that
God
already.
forbid this goes up on appeal for the appellate courts,
Let's see.
deputies,
Oh,
Mr.
did I?
Copeland and his counsel.
You've already played
How
that.
so-
That's the beginning.
No, it's because it's part. I think he came back up there, so I think he's just regurgitating.
Surreptitiously gotten information in regards to the court's private ex parte conversations with a party. I mean,
A
I wouldn't
party,
let- yes.
a witness who was sworn in Friday, the court's
It do sound like a repeat, right?
Yeah, you played that.
Yeah, I didn't go backwards. It was all the way through.
Tell me who
I'm not, I
tell me who this.
Okay, so yeah, you know what?
You've already played this.
No, you know what? This is 13 minutes, but I think they repeated it twice and put it together or something. You know?
That's what it sounds like, because
Yeah.
I just said the crucial issue's already been done. Somebody stepped off the 6th floor window balcony and they're on the way down.
I do want to play the clip when he was actually arrested.
Well, that's different. Play that.
Yeah.
So what's going to happen tomorrow with this jury trial? Are they going to bring the lawyer out in an orange jumpsuit?
Oh, no. Okay, so wait. Jeez.
See, that's the crucial thing. This trial's going on. You've got a defendant who's represented by this attorney. So what are you going to do? Bring the attorney out in prison garb? What's that going to do for the whole trial? You might as well start all over now.
No. I'm gonna play you.
No, I'm talking about the trial. I'm just saying.
No. Yeah, let me talk. I'm going to play Miss Merchant because she came in to be his lawyer of Steele who got arrested, and she told the judge he needs to recuse himself. So, but I want to
I mean, bottom line is at this point the only remedy for the fuck up is to start the whole trial over and declare a mistrial and get a brand new jury and start over from square one. Everything you've been hearing for weeks. She knows this is not going to stand up.
All right, let me
This is a fuck up.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And
Yeah.
you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial, and I assume you denied. but I'd like
What
you to
did I
deny our
say?
Motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Judge, you committed a grand theft fuck up. You didn't know how to handle it. Shit
We're
happens.
going to be in recess for the next 5 minutes.
See, what did I say? Consideration. What is the jury going to do? Are they going to bring the counsel out in prison garb? That prejudices trial. What is this man going to do? Be without attorney while all the rest is going on? The trial's got to stop. Can't go on. Mistrial is the only remedy for what the judge set up.
Well, he issued him to be in lockup for.
I don't care what the hell he did. It's
10
this
weeks.
beyond remedy. The
For 10
trial's fucked. It should have been a mistrial at this point. You got to start all over, get a new jury, and start the proof from square one. He fucked up.
Okay,
And
you're
I'm
using
not
the
holding it
F
against him.
word too much. You're using the F word too much.
Well, that's the best way to describe it. That means to plant a plowed row, by the way. It's in Oxford's dictionary as a standard formal English term. Fucked means to plant a plowed row with seed.
Okay.
So that's where the euphemism came, and it's a proper word. It's not even a slang word. It is an actual word and it's a verb.
But
So it's in
it
Oxford's
it goes
unabridged
bad.
dictionary.
It goes bad with the algorithm. So, and I'm all
Well,
about
it may be, but well, let's put it this way. He messed up. This is,
yes, big time.
in other words, if the jury finds out about this, it's dead. See, he just put it.
But the
I
jury
alluded
was
to
here
it.
watching.
Yeah. But I just said, I put it, and he just explained it.
Yeah.
It's like, it's a mistrial because is the defendant supposed to sit there without an attorney? No. He has one, so the attorney got taken away. So anything past this point can't be. So you got to delay the trial until you resolve what you did with his attorney. So if you lock his attorney up and the jury knows about it for this reason, you have irredeemably prejudiced the rest of the proceedings. The only remedy is a mistrial, start all over, select a brand new jury, find out if the jury has heard about this, and if they have, they're properly excluded for cause if they can't be fair, which is a problem. You've got this all over national television. It's a screw up. Next thing that goes on is you got to start the proof from square one. And you've seen what we have been through during the entirety of these whole proceedings. And also the judge puts himself in a position where he might get removed from the case.
All right. I want to play Ashley.
Very bad move. I'm not saying he's a bad judge, but he made a mistake this time. In other words, if you had an instant replay, it would show it was a bad call.
We get it. I want to play Ashley Merchant. She came in to be the attorney for Brian Steele, who was held in contempt. And I definitely
she's not being his attorney. She can't be. But what she's speaking
to representing him.
No, she's not. What she's doing is this: she's trying to save all of the work and effort that the state of Georgia has put into this trial by this reading and this ruling of the judge. And she's trying not to defend him, but show that there is an absolute constitutional necessity under the Constitution of the United States and that of Georgia that this not be done. In other words, as a party principal to this whole thing, she is saying, hey, you can't do this. You're going to screw this case up, and the only remedy is a mistrial. We have had to tie up the DA's office. We've had to bring in all these officers. We've had to bring in all these witnesses under subpoena. We've had to deal with all of the expense of housing, dealing with selecting the jury.
The video, Judge. Like,
yeah, I know, but she's not a witness. She's not representing him. That's the clarity.
Stop saying her words and let me just play the video.
Okay.
Remember as well that if anybody should talk with you about this case in your presence or hearing, you need to, of course, let myself and Sergeant Ingram know immediately. And remember, you cannot go by any scenes that may be depicted or may have been talked about during this case at all. And remember, you can't take any pictures, discussions, or anything like so. It's just that you're supposed to consider only what's been presented in this courtroom. All right, ladies and gentlemen, as well, thank you for your patience. Thank you for the attention that you've given this matter and the attention and patience you'll continue to give this matter. And unless you have any other ministerial inquiry of me, I'm going to release you till tomorrow morning at 9:30 for an anticipated 10 o'clock start time, okay? All right. All rise for our jury.
He's going to think about it and probably rescind his ruling, and somebody will tell him you should simply set this for a hearing to show cause.
How to witness asleep on the stand, honey. Education is very important. Bad parenting, and that's the end result when you drop out of school in the 8th grade.
Yeah, well, it is what it is.
And that's why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt, there's no supersedeas bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes to which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So he can, I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is because of the way this information was disclosed, it is troubling to the court and is very, since it was a ex parte communication. We won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that's the only thing I'm trying to do at this point in time. So I've asked your client for the last time if he would tell me who it is that disclosed that information.
Judge, can you come up to the microphone? Sorry.
Please.
Where would you like this?
Microphone, it'll pick up, madam.
Thank you so much. Just for the record, Ashley Merchant.
Which one?
It'll turn green. Yeah, it'll turn green. Yes, ma'am.
Is it on now?
Yes.
Okay, great, thank you. Judge, just for the record, is the criminal contempt, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. That I didn't ask or inquire about anything that was said. I just want to know who it was. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you're a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty. It's 152 Georgia App 399. And it says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215
215
Georgia App
Georgia App.
372.
Okay.
Also 215 Georgia App 349.
Okay.
That's Adams and Hasty.
All right. Let me take a look at that.
Isn't she one of the Trump lawyers?
Yes, Merchant, honey. Yes.
Yeah, well, she jumped in pro bono. I get it. She's citing the law. That's what I said. He can't do that. He's way wrong. He stepped out of the window and he's free falling.
1994.
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding. So most of the cases are a little bit older. But I do have other.
I love the fact that, listen, when it comes to research, oh my gosh, she is thorough.
Well, any defense lawyer already has this to hand. You can do this kind of thing. If you're good defense, if you don't know this kind of stuff, you're not a good defense lawyer. She's a decent little defense lawyer.
The challenge is I have space allocation.
You are so hard on these attorneys.
Well, of course I am. You're supposed to know what she does. You go into a doctor's office, aren't they supposed to be able to diagnose?
Concerns as well, and we have to vet people to come in. Then they can go to 8H and they can certainly watch the proceedings.
So it says doctor,
and Judge, for security
MD.
purposes,
Don't you expect the doctor to know this?
Give you all their names.
It still would have to be searched and still would have to be subject to the court's protocols.
And also, there's room in the jury box, and then there's room in the courtroom. So we would ask that they be
I
allowed to.
don't want them in my jury box, okay? No.
I understand.
Good for her. That's not a bad presentation. But the bottom line is, is you walk into your doctor's office, and these are doctors. They have doctorate degrees. They're licensed by the state to do certain things, like a medical doctor is. So
One
you
additional attorney,
expect your
and then
doctor to
Alex
know
Susar.
such things,
We're
don't
here
you?
on behalf
If your
of
lawyer
Jack
doesn't,
Halsey
he's
for our strike
ignorant. He
force.
doesn't
He
need
is
to
the
be
chair of the strike
practicing.
force.
He's
I'm the
supposed to get
president of
himself
the
up
Georgia
to
Association
speed
of
on
Criminal
this
Defense
stuff.
Lawyers and also a member of the strike force. So can he come in as another attorney co-counsel?
Yeah, I certainly may, sure.
Great. Alex Susar. Alex Susar. Thank you, Judge.
Henry Adams,
Do you think it's embarrassing that this judge had to Google the case he was referencing?
okay.
He doesn't Google it. You don't get this shit from Googling. It's called shepherdizing. It's a formal it's a formal legal reference service that's been in effect for 100-some years.
Cause there to be that issue presented, so I don't think, Adam, I'm gonna take a look at the other case.
And I'm surprised the judge doesn't know it.
372.
Yes.
The other case, just a second.
And there's several others when you're ready.
Yeah, she got a whole list of cases to refer.
Well, hell, I knew this. That's what I told you.
Right. No, but you know, people like to see video.
I know, but I told it to you. You wanted to see, she said the same thing I did. And the bottom line is why didn't he set it for a show cause instead of doing it immediately? And the bottom line is that he becomes a witness in this kind of, as he puts it, criminal contempt. What she said is correct. It's direct contempt he's talking about. But the bottom line is you do this right now instead of showing cause after these proceedings are over with. So you have to have a mistrial because that's the only remedy. What's this guy going to do? Sit up there with no attorney?
Right. And the guy, Woody, apparently he's the one that admitted to killing this guy Nut. And when I bring up, I'm about to bring up LA Pink, you know, so she could, of course, talk about her situation, but at the same time,
See, just because it's done in a court doesn't mean it's right. Just because a jury does it doesn't mean it's right. One of the problems, for example, you've got about the jury convicted Trump on 34 counts. Yeah, but the jury didn't get the correct charge of law by the judge. So when the judge doesn't give the correct charge of law, the whole thing is null and void. It goes all over again. So there are ways to use a court so you can manifestly cause an injustice. I've seen it, been there, seen it, done it, undone it, corrected it, stomped on it, gotten jacked up by the whole damn thing. And I admire this lawyer for saying, hell, I'll go to jail. I'm not going to sit there and violate this. Suppose that somebody said, hey, look, I've got some information you need to know. He said, well, you can tell me. Well, is it going to be confidential? And he says, yeah. Soon as he says it's confidential, it's under the attorney-client privilege. And they don't have any business for finding him in contempt, meaning the judge, the court, the people, on behalf of, there's no reason to find him in contempt. At that point, he may have a problem with security, but as soon as he says attorney-client, it's off, dead. That's sacrosanct in American law. And that's what's wrong with a lot of this BS up in New York, is they totally violated attorney-client privilege. Cohen testifying against Trump is an example of that.
Right. So this is the ending part.
Next few evenings.
Where's Miss Bumpus?
I have a matter.
Uniform, Sierra, Oscar.
You're a good man. And you reflect. And Mr. Steele, if I could ask you to take the podium, please, as well. Now stand next to your attorneys.
So that is his attorney.
Okay, Ms. Merchant, Mr. Steele, and I apologize.
Mr. Susar, Judge.
One more time?
Susar.
What, spell your last name for us?
S-U-S-O-R. Sierra, uniform Sierra, Oscar.
You're a good man. Good man. Okay. All right. Okay. All right. Thank you, sir. Okay, Mr. Sousa as well. All right, counsel, I've made a clarification or to the order of contempt. Mr. Steele, I am going to hold you under, still hold you in summary criminal contempt pursuant to OCGA 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated at the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court. And that will be entered and e-filed. And you may take whatever steps you and your counsel deem appropriate after that. Okay?
Can I ask a question?
Sure.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, if that comes to pass, you have my support. I will talk with our sheriff and we may be able to make that work. Okay? If that should.
How the hell are you going to have an attorney-client privileged conversation between a defendant and his lawyer when both of them are in lockup and neither one of them is entitled to the confidence that's necessary to exercise that privilege? When you have a lockup situation where a defendant is locked up, you have a special attorney room that's clean. It does not have recording devices. It's clean of any kind of video situation except a non-voice, non-auditory one that may be appropriate for security purposes, but that's it. So how are they going to have that conversation? You're going to have the client talking with the defendant in jail? See, that's a very chicken shit resolution.
Yeah, to give him contempt on the weekends. I don't.
Yeah, and how is he going to, while this trial's going on, have necessary conferencing time and consultation time with his defendant? It's chilling to the whole process. It's just totally effed up. There is no redemption to this, and he's made a motion for a new trial, so that'll be pending. So anything they get out of this as a conviction is going to be questionable from this point on.
Right. Hi, LA Pink.
Hi. Woo. Already started on fire, on fire.
Sorry for the.
That's not on fire. That's just basic. That's just basic.
Well, introduce yourself again to the audience here, because you've been here. This is your second time, third. Yeah. So just quickly tell us who you are, and we're going to get right into the business.
Absolutely. Well, I am L.A. Pink. I am the First Lady and President over Street Groomers. I am a community leader, advocate for the community. Not an activist. I don't act in all of this. So I don't consider myself an activist. Activists is in these day and times, they just act, and they're not like our Harriet Tubmans and our, they're just, yeah. But I'm a community leader.
Okay. All right. So you have, not only you're a community leader, you have an issue with Fani Willis, DA office, and also particularly when you talk about the county of Fulton County, Sheriff LaButte. We've talked about Sheriff LaButte recently. He's not as known nationally as Fani Willis. However, he's part of that corruption tree of Fulton County. So tell us about your situation with Sheriff LaButte.
So my situation with Sheriff LaButte is I was brought a lot of information Well, let's go for a little bit back forward than that. Backwards. I mean, more back. I campaigned for him years ago when he first came in office, thinking that this was going to be a man of integrity, a man, that was about the community, the things that he displayed. I was introduced to him by an individual, and that's how I even met him. And by this person that being near dear to my heart, I jumped right on board because I was like, hey, they introduced me to him. It has to be, that's like Judge introducing somebody to you. You're like, hey, okay, let's go. Or you vice versa. However the case may be, wind up getting involved, going door to door to get him in office. And as the years went by, I began to get so much different information. So as the re-election came up, this was the proper time for us to get him out. I had given so much time of, so much of my time to get him in office. So I felt like it was time for me to give extra time to get him out of office. And so that's what I'm doing.
He was a gay porn star, right?
Mm-hmm.
A porn star is the sheriff. And by the way, for the record, we have copies of we have clips from some of his porn performances.
Mm-hmm.
Is that right, Miss Dana? Can't hear you.
I'm running my damn mouth.
Okay, I was wondering, like, what is happening? She signaling somebody over there talking to her.
Yes, go to the website, therealdananetwork.com, and you can see Sheriff LaButte during his porn days before he became sheriff. So,
Mm-hmm.
Get your fine butt back under these covers and let me get on top of you.
right. And this is the same man harassing the residents, taxpayers of Fulton County. This is the same man, who's trying to cover up all of the corruption going on in the Fulton County jail.
This is the same man that's running a trap house out of the jail. And I say that because who has a drug bust at their own jail? Like, that's unheard of. Who says that a woman is bullying them? That's what I'm going to court for tomorrow, is because he lied under oath, saying that I bullied him, signed a sworn affidavit, and lied.
Right.
And by the way, looking at it, it wasn't even the proper court. He swore out his complaint in a domestic violence court because allegedly in his poorly written document done by hand, not typed out, he claimed that you were revealing embarrassing information that's supposed to be public record. Interesting. Domestic violence. That's not even the proper court. That was abuse of process. I'm not a lawyer in Georgia, and I'm not practicing. I'm just saying that's what it sounded like to me as a layman's opinion. I'm not giving you legal advice. I just happen to have had 50 years plus experience in this stuff. So my lay opinion might be for whatever it's worth. Anyway.
So what's going to happen tomorrow? Because we need to get into some other stuff, but I want you to talk about your situation right now. So what's going to happen tomorrow when you go to court? You're taking him to court. You're suing.
Absolutely.
Okay.
Well, tomorrow is the warrant hearing. So what will be happening tomorrow is we present the action of fault of what he did wrong, as far as the violation, the swearing up under oath, signing a sworn affidavit paper that is against the law. We got I sent it to you as well, of all the laws he had broken. My attorney Mario Williams, he's not feeling good today, you guys, and he has to prepare for tomorrow. So he wasn't coming on today because he wasn't feeling too good.
Okay, he's your attorney. We interviewed him.
Yeah.
2 weeks ago. It was 2 weeks ago. Yeah. Well, I'm thinking that
he represented the whistleblower.
Yes. I forgot he's your attorney as well. Yes, great guy.
As well as Misha Mainers.
Yes. Okay.
Yeah, he's our attorney.
Mm-hmm.
So I sent you a video too of him already.
I'm gonna play it when I edit the video.
Okay.
Yeah.
So, but yeah, that's what we'll be going to court for tomorrow, is to get them to issue a bench warrant for his arrest.
The sheriff?
Yes, the sheriff.
That's possible.
He broke the law. Like,
Well, you're asking for a warrant. A bench warrant is
I
when a
mean, not a
warrant
bench
has
warrant,
been,
but a warrant for his arrest. Yes.
yeah,
Excuse
a
me.
bench
Clear me up.
warrant.
Clear me up. You know what it
A
is.
bench warrant is when a warrant or process is already issued and the party does not show up.
Right.
If he's been indicted, what gets issued is not a bench warrant, it's a capias.
Okay, gotcha. Well, we are asking for him to
A
be
warrant.
charged. Yes, him to be, tomorrow's a warrant hearing is what it is
Okay.
for his violations that he had done.
Right. And you're just one of several people who he tries to bully.
I am the one and only that have ever done this
That
on a sheriff.
right.
She's she's standing up for her rights and she's exercising her own options within the system.
But he's not, but you're not the only one that he tries to intimidate. You're just the only one that's actually fighting back.
Absolutely.
Yes.
Absolutely. I am the only one he has ever put a TPO on as far as a citizen trying to silence them. You know, and especially in this matter. I don't know if he's ever done it against his wife or not. I have no clue. You know what I'm saying? But I know I'm the first citizen to ever step up and go to these extremes. They said ever.
Right. All right. So
Thank you. Stand up for the rights of the people. That's what we need more of.
Right. I mean, because when someone like yourself does that, it makes it other people it was like, okay, well, I could do it too. And it makes the process easier and more common, to where you let these people in these positions know, listen, you cannot get away with intimidating, a citizen, a tax-paying citizen, because they think they could just get away with anything.
I mean, just like what Glanville just did, he did the same thing. Like, you violated the law right in our faces, and now you're going to try to sit up here and try to make men push a power to say, oh, you're in contempt of court because you won't tell me who told you. You wasn't even supposed to be in this situation for anybody to be in contempt, and for you to be even being addressed with what information he had to not give him. So every action has a reaction, and the actions that they are showing is that they are breaking the law because they are being forced now to abide by the law.
And guess what? And what we just got through looking at before you came on, whoever told the lawyer is in effect a whistleblower, because the judge should have disclosed to all parties that he had an ex parte communication. So the lawyers didn't deal with it, any of them, but I would have evoked the Whistleblowers Protection Act you've got down in Georgia. This person who told him was a whistleblower, so because of that particular extra one, he needed to hold this confidentiality close to heart.
But as we can see with the whistleblowers, they don't care about them down here. You know, they feel like if it's something that they want, they will break the law to get it. Why they're Fani Willis and all the rest of them talking about nobody is above the law, but they continue to break the law. You know, it just kills me. I mean, you just had Fani Willis have all of these pulpit pimps come up there and stand with her and go all the way against the law because they just broke their 501c3 endorsing. They are not supposed to endorse any candidate by any means up under the 501c3 bridge. And they went ahead and did just that. So, you know, they really just don't care. I mean, Jezebel got them in a spell. And it is just
Jezebel got him in a spell. I like that. There you go.
I want to bring something. I want to highlight this story because this story went viral as well. Let me just share this. So it says Georgia attorney and former Atlanta police officer sentenced for $15 million COVID-19 relief fund conspiracy. So a Georgia attorney and former city of Atlanta police officer was sentenced today to 7 years and 3 months in prison for conspiring to defraud the Paycheck Protection Program, PPP, of approximately $15 million. According to the court documents and evidence presented at trial, Shalita Robertson, 62, of Atlanta, conspired with Chandra Norton to submit fraudulent PPP loan applications on behalf of businesses that Robinson and Norton each own. The fraudulent loan applicants falsely inflated the number of employees and average monthly payroll for each of the application businesses and included false supporting tax documentations, inducing larger PPP loans than Robinson and Norton could legitimately obtain. Robinson
She bought a 10-carat diamond ring and a
and
Rolls Royce.
And a pink.
Let me read it. Robinson and Norton submitted fraudulent applications on behalf of 4 businesses Robinson owned, resulting in $7 million in PPP loans deposited into bank accounts Robinson owned and controlled. Robinson then used the loan proceeds for her personal benefit, including purchasing luxury items such as a 10-carat diamond ring and transferring funds to family members and to Norton. So
Don't forget the Rolls Royce.
The federal grand jury convicted Robinson in December of 2023 of 1 count of conspiracy to commit wire fraud, 3 counts of wire fraud, and 1 count of money laundering. Norton pleaded guilty in November 2020 and is scheduled to be sentenced August the 14th. Now, here's my question. She donated money to
Fani
Willis campaign.
Yes, she did.
And this would be a legal question for the judge. Can Fani Willis kind of be caught up in this because you accepted money when someone was under investigation for fraud and stealing and IRS,
Commissioner Hall chasing balls did too, and Commissioner Ike Arrington did too. They're her whole little crew. That's her whole crew. Fani Willis's.
Right.
It's a culture of corruption
Yes.
in Fulton County. It's a
Yes,
corrupt
indeed.
culture of corruption in Atlanta.
Mm-hmm.
And too
Fulton
many
County
of them have
massacre.
connections. Yeah, too many of them have connections to a past generation that were involved with civil rights. It's really kind of a hell of a corruption of a legacy. But anyway, it is
So
what
the
it
Atlanta
is.
prosecutor jailed for $15 million COVID fund donated to Fani Willis as she splurged.
Yeah, that's what I wanted you to get to. She wasn't just a cop and a lawyer. She was an attorney general.
I said that.
That's what no, you didn't. That you just said it for the first time. No, you did. You didn't say it.
Yes, I did.
You read Dana. That's why I asked it. So what else is she? You said she's a former cop. Yeah, you just did. But that was the point.
Oh my God, Judge, please just stop. Because when I started talking about this story, I read here under the justice.gov, she was a Georgia attorney and former city Atlanta police officer.
That's not the important point. The thing was she was a district attorney for Atlanta. All the rest of the stuff pales in comparison because she was one of those people in charge with ultimate enforcement of the law.
Assistant city attorney.
Yeah, well, that was the punchline.
No, it wasn't. The punchline
Yeah, it is. The punchline, she's not a cop. Any cop just flat foot out there.
No,
he may be doing good or she may be doing good. She's a lawyer, but she could be a crooked lawyer. But the fact that she held a public office.
I know, Judge. She used to be a cop, and then she went on to being an attorney and then assistant attorney for the city.
That's why I said, go. What else was she besides being a cop and a lawyer? That's the important part.
Exactly.
In other words, somebody who held a public trust that is squawking about other people violating the public trust, in fact, got convicted, and the conviction sustained. The appellate process has been where it was, and she's about to start serving the time.
All right. So I have the notes here. I don't want to just jump in. I don't want to jump ahead.
Why not?
Because you don't do that. You don't do that. You don't jump ahead because you're going to be missing out other stuff that you should be saying.
Yeah, it's just like you stepped out of the 6th floor balcony and you're on free fall.
Let me finish.
Ain't nothing else.
It is something else, because I'm trying to say, when she donated to Fani Willis, this woman was under investigation. So what is that illegal ramifications? Isn't that something?
It depends. The answer is it depends. Did Miss Fani know about it? And then the other thing is since she's in the RICO, there's a federal RICO thing here. If that is the crime element, is what she donated to Fani part of the fruits of the criminal activity?
So it says Shalita Robinson, 62, donated $1,000 to Fani Willis' Democratic primary election campaign around the time she got the massive payouts obtained after declaring inflated businesses to the Paycheck Protection Program filing shows. A few years later, the Georgia jurists would charge former President Donald Trump with racketeering following 13-count indictment, accused him of trying to illegally overturn the 2020 election. Now, if you accept money from someone who is committing fraud, wouldn't that connect you to be part of a RICO situation?
Depends. Depends.
What happened?
It depends.
Hello?
I'm
Can
here.
you guys hear me?
Yeah.
I can't hear you.
We hear you.
I can't.
Hello?
Can you hear me?
I can hear you.
So just say yeah. Nod your head yes if you can hear me.
Yes.
I can't hear none of y'all. Give me a second. Hello?
Hello?
Yeah. We hear you.
Yeah. So you guys can hear me. Say something, LA. Just y'all say something. I want to know if
Hello?
the audience can hear you. Speak.
Hello?
Testing 5498111.
Can you guys hear them?
Mic check.
I'm
Can
the
you
only
hear
one
me?
who cannot hear.
Can you hear me?
Testing.
1, 2, 3.
I need to get a new broadcaster. Are you serious? The one I'm supposed
We
to do
hear
now.
you.
Go out and come back in. Stay. All right, you guys stay there. Stay there. Stay there. Stay there. Stay there.
Wow, we will be. The crooks
Oh, man.
cavort. While the cat is away, the mice will play.
Jesus.
Or in this case, while the cat is away, the rats will frolic. While the cat is away, the rats will play.
Can you guys hear me now?
Yes.
I could not. All of a sudden, it just went out, and I don't know if it's this thing, or as soon as I said, if you accept money for someone who is committing a crime, a fraudulent crime with the IRS, with the federal government, all this other stuff, doesn't that put you or place you part of a RICO, a conspiracy?
Maybe. But it certainly would put some prosecutorial agency on notice to investigate it. And that's the problem here. Miss Fani is in charge of the one for Fulton County, where the allegations seem to put the problem, and she is part of the problem. So do you think she's investigating herself? So probable cause being developed on her own incriminating statements when she, I'm going to take the witness stand, I decided, and she incriminated herself and developed multiple leads and probable cause and self-admissions to criminality, that indicated it's time to look into it.
Mhm. So, go ahead, LA Pink. Please speak to this woman, Shalita. You know, have you heard of her before in Atlanta?
No, I have not. I had to start getting that, like, people were just sending it to me. I mean, they send everything that happens to between her and any of them inside the Fulton County. And so when I just started getting it, I was like, whoa,
Mm-hmm.
what in the world is, but it didn't surprise me because everything in Fulton County is corrupt.
Right.
Everything. So it ain't too much that's,
That's the culprit, isn't it? Bought a 10-carat diamond, which is worthless. I remember a trial we had. De Beers sent over some assassins to assassinate 7 people. They got 4 of them they killed, badly wounded a 5th. And the Bush administration, George Herbert Walker Bush, declared diplomatic immunity and sent them back to South Africa. And the testimony during the 3 weeks of trial we had was that a $10 million diamond was worth maybe $8 million. No, about $8,000 because of the cutting perfection, because Oppenheimer De Beers was securing a lot of mess over in Africa that was being disguised as tribalism because they wanted to maintain a diamond monopoly, which they had from the English monarchy in England. So 99.9999, except for percent of the world's mined diamonds were in their vaults, and because they trickled them out, that's why diamonds have a value. Intrinsically, they're very common, since carbon is quite common.
What are we
Then they
talking
get
about?
belched out by volcanoes. This fool spent $10 million on, well, not, yeah, on a 10 million, what was it? She spent all this money, millions of dollars, on a 10-carat diamond in a Rolls Royce.
So I want to play her here. She went on somebody podcast. I don't know how long ago this was. I don't even know who this podcaster is, but she's trying to talk to, speaking of how she has so much integrity.
I choose integrity and whatever else it brings. I don't choose selling your soul to the devil.
What part makes it selling your soul?
Because that means I'm willing to do anything, belittle myself and degrade myself for the love of what? Of $1. I'm not going to do it. My integrity, what my kids and how my kids respect me and view me means more to me than me earning a quick dollar, portraying to be something that I'm not. Or it may, they very well may be that way. That might be true. What she's singing about may have just happened. I don't know. I'm not there to judge. I don't care. But I'm not willing to put that thought out there. I choose it.
Now, why?
Notice the sincerity of the lying sleaze as she protests her innocence, and she talks of integrity. And of course, she sold her soul for a bit of pressurized carbon and one Rolls Royce vehicle. My. And she betrayed her trust.
Yeah.
By the way, who's this interviewing her? She's a pretty looking woman.
What was that in the background, Ellie Pink?
Over here?
Yeah.
Oh,
Well, who are them kids?
girl, my great nephew. Hold on.
They're like, it's
Don't.
they need to be.
What's going on?
Tell them kids to go to
Sorry,
bed,
y'all.
honey. Just because you out of school and in summertime, you still got to go to bed before 10. Child.
We didn't get out of school until the end of June, excuse me, and went back in September in California.
So again, my question is, can Fani be connected because she took money from someone?
It depends. Considering what we've heard from Fani by our own incriminating testimony, under oath, probably. But They have to prove the situation beyond a reasonable doubt. But there might be probable cause to go further.
Mm-hmm.
And another avenue of investigation.
Okay. Well, she
A
received
culture of crime, you know?
Well, she received $1,000. If that was anybody else who received money from someone in this type of situation, they would be brought up on charges.
Maybe, but you don't know who's contributing to a campaign fund. Nobody goes, "Oh, that chick's been indicted." Nobody does that.
Mm-hmm.
That would be really unrealistic.
Mm-hmm. All right. So,
but by the way, that doesn't because she under indictment, it doesn't remove her First Amendment right to support a candidate. She can support Fani.
Well,
Fani, excuse me.
Being that you were so adamant about this woman being a assistant attorney for the city, what are you trying to allude with that? Why are you saying that was the meat of what? Judge?
Oh, me? I thought you were asking.
No, you don't want
Miss Pink.
You're trying to tell me.
Well, the point is, she had an office of public trust, and that's supposed to, unlike what happened in Baltimore, that's supposed to enhance punishment. That's supposed to merit a harsh sentence as a deterrent to others who hold the public trust from violating that public trust. It's unfortunate when people that the public has deemed trustworthy prove not to be. It undermines the entirety of the government process.
And that supposed to have been the meat of whatever?
That's the important part. This is not just some hoi polloi, somebody floating around.
That's what I'm asking. Why is that?
Because we trust people to run our government. They are the ones that speak for us, act for us, appropriate for us, legislate for us, prosecute for us. And when they violate the public trust, it's very bad. That means that we've been betrayed. Treason is what it used to be called in most societies, but America had been subject to the experience with the English crown and the way they treated treason, so they made it a special category. There has to be an active war situation. There have to be two witnesses. Certain circumstances have to apply, and it's the only crime defined in the Constitution itself. So they made it very tough proving it, but in most other societies, this would be a form of treason if proved by whatever standard they have.
But people are still voting these people in.
They're voting. More the fools. They have a saying about the American system. You get the representation that you deserve, and if your reputation isn't shit, the people aren't shit because they aren't acting like they deserve good representation. Because they are not effectively, intelligently, and advisedly using their franchise, meaning their right to vote.
So, LA Pink, please. All right. I want to finish up with you. Tell us your final thoughts on this and the whole Fani situation. Have you been keeping up with the YSL trial?
I did. We watched it today, and everything that's been going on. And all I could continue to think about is everything that is being exposed down here. When I say it's a trickle effect and it is happening rapidly, everything is being exposed. I mean, because one thing that y'all are not paying attention to, that YSL lawyer has to go and sit into this jail that we've all been talking about, that there's no leadership that's directly inside. So hopefully he can even just take out of all of this too, from top to bottom of what needs to be changed, you know, from to help continue to fight the fight on a bigger scale. because for you to have to be sentenced to a jail, and you're saying for the weekends or whatever days it is, for him to try to teach him a lesson, it's unheard of.
You told me something earlier. And I don't know, for legal purposes, I don't think if we could mention it, even though it's hearsay.
Oh no.
It's hearsay.
No, just say alleged. What the streets say. I always say what the streets say.
Right.
You know, this is what the streets say, because the streets is talking.
So the streets of Atlanta and Fulton County is talking, and you have your ear to the street. And what you said to me earlier, just going back to this YSL, Fani Willis is connected in this YSL trial, right?
Absolutely.
It just so happened the guy Woody, who testified, I believe it was today, he admitted he was the one that shot and killed the guy Nut. And can you tell us who Nut was and how Fani Willis is related? Well, is connected to Nut, which is probably one of the main reasons why she started the RICO case against YSL. And this is alleged. So what is the rumor mill with Fani Willis and Nut, who was killed by Woody, apparently?
Right. Well, everybody can just hashtag super friends. She'll know what that is. But Nut and her, we'll say allegedly, was in a relationship. But we have proof. But however the case may be, alleged on here, so that we can make sure we keep stuff clear to people's happiness. But this is for me, and this is what I feel, that is a revenge RICO. It's not a RICO based on, oh, you broke the law. I caught you breaking the law, and this is something that's being done. This is something that this is the reason why she has to go back. If anybody is paying attention, Big Nut's name is mentioned inside of this RICO, of one of the top reasons why the RICO is taking place based on his murder. So it's from allegedly YSL was supposed to have done it, not had something to do with it, but had done it. Young Thug was supposed to have had it done to take over the streets. But
she was messing with, she was romantically dealing with Nut,
involved with
him. He gets murdered, and then she starts to build a RICO case against YSL.
Absolutely.
And speaking of the same RICO case, is also alleged that she had something intimate going on with Judge Glenn Bell.
Yes, Glenn Bell.
Glenn Bell. So she slept, allegedly, the rumor is she slept with him too. She slept with the judge on the YSL case. She slept with Nut, who was one of the murder victims, which is why this case even started. She slept with the former DA of Fulton County. What is his name?
Paul Howard. And she also slept with, which we all know, which is how all this thing kicked off with the Fani trilogy, Nathan Wade, who she hired to be special prosecutor on the Georgia case against Donald Trump.
Don't forget the DJ by day.
But the DJ
DJ not by day, but by night. And the government employee by day. Yeah, I mean, it's just.
Oh, we don't care about DJ.
Remember, the problem is all of these pulpit pimps are sitting up there dealing with promoting adultery in their churches by promoting her. And endorsing her in her campaign pledge to the people of Fulton County that she would see to it that this didn't happen. And remember, she said, I promise you, and you played the recording, Dana, that I will not allow this to happen, where in this office, the employees sleep with the supervisor. So she said she hired Wade first and then started screwing him. That was her own testimony.
Well, so she denied it first.
But she got on the stand and testified, and she says the affair developed later.
Stop. Let me just lay it out, because we're short on time here.
I just did. You don't need to lay it out again.
You don't lay nothing out. let me finish interviewing LA Pink because I was going somewhere before you interrupted.
Go
So
ahead.
she slept with the former DA who she beat to become DA. She slept with Nutt. She's allegedly slept with that judge that's on the YSL case, but we all know for sure that she slept with Nathan Wade. And the reason why I'm running this down is all of these things that is going on when we talk about corruption, when we talk about, conflict of interest, this is a pattern in this county, correct?
Absolutely.
So what are the people of Fulton County doing to rectify this?
Nothing. They all they do is brush it up under the rug because it's not an alleged that Sheriff LaButte is sleeping with April Moore and have made her a major up under him. It's not that any of them that's in his office that have slept with other women, that this is what they do. This is Fulton County massacre. It's just a corrupt and just environment that if you say something, then your job is at jeopardy. And if you don't, then your life is at jeopardy because it's going to affect you eventually, regardless, regardless of how you want to look at it. So just like the three gentlemen that had said something and spoke up and wanted to go with a different candidate, they got fired. So anybody that goes against the grain of anything that's going on in Fulton County, they come for them. If you guys have been watching anything that's going on with Fulton County, we had a commissioner, Khadijah Abdul Rahman. They came after her, for her speaking against the things that they were doing, not allowing Fani Willis to get any money, not allowing Pat LaButte to get any money. And they came for her. They came after her. They began to try to ruin her campaign, try to say she was a Republican, they tried to do everything in their power. Misha Maynard, same thing. When you go against them and you go against the grain, they come after you. When she was a Democrat, they literally was stalking her home, talking bad about her in her face, like just making her days just miserable being a Democrat. And so
Okay, ladies, the reason I brought up the DJ is a very important one that ties in. What do all these people have in common? They have government jobs, right?
Yeah. Mm-hmm. Corruption.
What did Fanny's father, George Floyd, John Floyd, say? He was a DJ and he had a daytime government job. So was this person she's sitting up there shacking with one of the people we just discussed who had a part-time DJ gig at night, and by day he worked for the government, which is right back in the thing. This is more corruption. Who is he, and what connection does this government employee by day have with the misappropriation of funds and more of the same? It's a very important situation because it
narrative with the DJ. But what
but you see, here's the thing.
Wade, who was
listen to me. Listen to me. From the way she testified, in my experience, it's likely she made a Freudian slip by the circumstances that a daddy just testified to, and he didn't make the connection, but it's got a big connection. She's sleeping with somebody else on a regular basis, shacking with him, who had a government job, and considering government, we've heard here, everybody's got a government job and government money. There is clear circumstance that shows probable cause or reasonable suspicion to suspect that government money was misappropriated, misapplied, embezzlement, outright stolen or diverted. We ought to be on notice that something got brought up. You notice how she has totally avoided talking about this individual who's DJ by night, government employee by day, and what connection does it have with the big picture of corruption in Fulton County? Who is the government employee? You notice he was never identified.
I don't really care. I want to give LA Pink.
I'm saying
don't
go there. I'm giving look.
Word.
Look, I'm giving
No,
her some.
yeah, we
Listen,
have to move
listen,
on. No,
listen,
because that's
Miss
not
Madam Pink.
topic.
Madam
You
Pink,
said
you're
it.
getting into it.
Said it.
Find out
Mm-hmm.
who this daytime government employee is, and I suspect you will find the key to bringing down the whole corrupt house of cards.
All right, thank you.
Mm.
LA Pink, you get the last word, please. So, and then also let people know where they can follow you, support you at. But give us your final thoughts.
On everything, my thoughts and prayers are that because I don't live in Fulton County, I service Fulton County. I pray that they could get involved, the Fulton County residents and the people that live in Fulton County that really is paying their tax dollars. You know, my dollars get spent because, of course, like I said, I feed the homeless and I do, you know, my community work out in Fulton County. So that's why my expectations is going to remain high of seeing things being brought forth and seeing things being changed. I try to tell people all the time, it was Harriet Tubman that came and made sure that we were free and that we are in the position that we are in right now, you know, and so many others that paved the way of our ancestors. And they were all Black. They made sure of that. So for people to say, why do Black people got to go against Black people, is because Black people are doing corrupts right now. And I need to make sure that we get some people that are going to be in office that is going to do the work. Whether if you're Black or white, this is not a Black thing, not a white thing. This is the right thing, that we get white people in office that are doing the work. And I'm Black and I want to see Black people off in there doing right.
Right. And what is the website? Did you say the website?
It's www.streetgroomers.org. And then
.org.
.org. And then if anybody wants to donate, it's LA Pink 1027 or 678-984-9241. That is my Zelle account. You can follow me on any of my social media up under LA Pink.
$sign LA Pink 1027 for Cash App?
Yes.
Okay. All right. Look, I gotta have you come back on, and someone you referred me to, they're gonna be coming on Thursday show.
Okay.
I mean, if you do have time, you could come on Thursday, you know, along with that person, so you could give us an update on what happens tomorrow with your court situation. So definitely want to have you come back and try to come back this week, Thursday, so you can give us an update.
And I sent you the video too of me and Mario. We did a press conference.
I'm
play that
I'm
so that
I'm
people
gonna play
can
that in the
see.
clip
Because Mario talks about more of the legal piece. That's why I wanted him on tonight, because he gives the legal piece of it. You know.
Right. No, I'm definitely going to insert that clip when I do the upload. So, because I always edit it and I do the upload, and I'm definitely going to insert that.
Then they can see. Absolutely.
Thank you.
Thank you both so much. It's always a blessing to be on with you guys, to, you know, talk.
And look into that. I think you're going to find something.
All righty.
All right.
You know, I will. I got you. I'm on it.
All right.
So I'll talk to you later in the week and see if you're available this Thursday as well.
Most definitely.
Okay. All right.
You guys have a good night.
All right. You too.
Kingdom blessings.
All right. It's already getting to the 2-hour mark, and this is why I move along. I don't care if people get an attitude that I cut you off, and I'm going to continue to cut whoever off. We got to move the show along to get it under 2 hours, especially on a Monday. I don't care. So
okay, we're getting to Putin, right?
Well, I don't think I even feel like getting a Putin right now.
Putin shouldn't be too long. It should be short enough. The sending of potential equipment down to Cuba. So, you know, payback's a bitch, isn't it?
Well, I have notes and I have a layout of the show in front of me.
Okay.
And I always say this, I know what I'm doing. When I bring something up, just go with it. Just go with it. Don't jump ahead. Don't try to jump ahead. Don't think that I forgot anything. If you think I forgot anything, tell me when I'm done.
Okay, now back to the point at hand.
Putin warships deployed to Cuba, but there are no nuclear missiles on the ship.
They don't have to be. The retaliation does not require nuclear missiles. They haven't done anything nuclear since August 1945, Hiroshima and Nagasaki. So it is what it is. And considering the short distance from Cuba to southeastern United States, a few of the same kind of missiles of similar nature to what Ukraine is deploying over there that jackass in charge, his administration gave authorization to use to attack Russia. You know,
Isn't this a violation of the Embargo Act or something?
the Embargo Act is what the United States decided to impose through rank exercise of power back in the early 1960s against a developing country that had just changed government from a fascist capitalist situation to a communist one that has proved to be pretty strong, resolute, and long lasting.
Mm-hmm.
So you bring in the same kind of weapons there that the United States is deploying in the Ukraine and allowing the Ukrainians to do what they wish with them, then tit for tat. The other thing is that there is another story to the Cuban Missile Crisis, and that is that the U.S. really didn't win. It was what Nikita Khrushchev wanted. By the way, Nikita Khrushchev is funny, is from Ukraine. He was a Ukrainian. He was a commissar, senior commissar, who wound up being ruthlessly elevated to being premier of the Soviet Union. Now, that said, Nikita Khrushchev got what he wanted because it was a trade-off in a similar situation. The United States had deployed intermediate range ballistic missiles with nukes on board to Eastern Europe, or at least the eastern part of the Western Alliance, NATO. And there was a long telegram, took about 3 hours to deliver. And Khrushchev and the guys sent Kennedy and the guys a list of the serial numbers of the launchers and their geographic locations, latitude, longitude, where they were. And the U.S. tried to move them, and they upgraded that thing. So the deal was, we'll withdraw the missiles. You can make it look like you backed us down, and you move your missiles out of Eastern Europe, and we'll call it a wash. And that's what Khrushchev was trying to get. So it looks like a similar situation. You're arming Ukraine, we arm Cuba. So what are we going to do to resolve this dilemma? You don't want this 45 miles off of your eastern seaboard. That's well within range of the missiles in question. So what do we trade? It's an interesting diplomatic move.
So what do you?
Chess.
So what is the next chess move for Russia, and what should be
Not Russia, it's the United States. What are you going to do? Cubans will have these non-nuclear missiles. You've been supplying non-nuclear artillery missiles to Ukraine. Are you going to keep supplying them, or are you going to back down? So we'll back down.
Oh, okay. So it's more like, we're going to play your game, but we're going to be right in your backyard doing
We're
what
going to be right in your behind. So what are you going to do about it?
Because Ukraine is in Russia's backyard. So Russia.
Well, Ukraine used to be part of Russia. If I can give people an explanation very quickly, it's like if Texas decided to secede from the Union, and some Texans wanted to get back into the United States. The United States, for a number of reasons, said we want Texas back in the Union. That's what it is. Ukraine used to be the biggest state in the Soviet Union, the biggest republic.
Mm-hmm.
And like I said, the first missile crisis was played off between John F. Kennedy and Nikita Khrushchev. Nikita Khrushchev was a Ukrainian.
So how should the United States respond to this?
I know what I do, but that's not my pay grade. They're not paying me, and they got a jackass that is getting paid to do that, and another jackass in the background trying to take over. So do you think they know what to do to protect the United States, or are they just going to fumble and stumble through this some more and set up more awkward positions? And they've got a chess master. His name is Putin. Do you think he's going to outplay Biden, who poops his Pampers, on June 6th?
When the Secretary of Defense have a plan?
The Secretary of Defense is an assistant to the president, who is head of the administrative executive branch of government. Secretary of Defense is subordinate to him. He's only part of his cabinet.
Right. But shouldn't he come up with a plan to present it to the president?
It's only advisory to the president, who is by constitutional authority the chief diplomat of the country.
Right. And the president is the commander of the military.
Yeah, he's chief diplomat and commander-in-chief of the military. So guess who that is right now? And when his senile butt has to retire for the first time, or resign first time since Richard Tricky Dick Nixon, who's going to take over? Mrs. Imhoff. And does she inspire you with confidence and the ability to handle this? Hell no, scares the crap out of me.
So we're basically screwed until January, when Trump is sworn into the presidency.
Mm-hmm.
All right. I want to move on to Trump news. Real quick. We're not going to be on it long. Give me a second. I'm going to share this.
Son was in court. His political rival, Donald Trump, sat down for an interview today with a probation officer ahead of his sentencing. Laura Jarrett joins us now live here on set. So, Laura, you're getting details about the meeting with the former president?
Yes, Tom. Typically, this type of interview is done in person, but this one was done virtually with Mr. Trump accompanied by his attorney, a source familiar with the matter describing it as brief, lasting less than 30 minutes. Now, the former president was convicted last month of falsifying his business records to cover up a hush money payment to an adult film star. He now faces 4 years in prison or just probation. Typically, someone would be asked about finances, family, and other factors that might support a lighter sentence. That all goes in a report, just one piece of what the judge will consider for that sentencing scheduled for July 11th.
All right, Laura Jarrett, we thank you for that.
Tonight, that's that. And it was something else. One more thing that I wanted to share. So it says Trump. So that was the probationary hearing. And now it says,
I don't think there was much of a hearing other than lawyers saying, we decline to answer that, we decline to answer that, we decline to answer that, we decline to answer that. Right. They got a long list, and then they just went down the list.
All right, so this is Trump classified documents. Judge rules on motion to dismiss case. Judge Cannon has rejected multiple other motions to dismiss the case. Federal judge presiding over the classified documents case against former President Trump has denied a motion to dismiss some of the charges in the indictment.
That's not surprising. There hasn't been any factual findings or findings of fact on the case. It would be kind of premature right now.
Mm-hmm. Trump's legal team has sought to throw out more than a dozen of the 41 counts in the indictment, which accuses the former commander-in-chief of illegally hoarding classified documents from his presidency and conspiring with others to conceal sensitive files from the federal government. The defendant had challenged counts related to obstruction and false statements, but the U.S. District Judge Aileen Cannon issued an order Monday saying that the identified deficiencies, even if generated some arguable confusion, are either permitted by law, raise evidentiary
Evidentiary.
challenges, not appropriate for disposition at this juncture, and
That's what I said.
or do not require dismissal, even if technically deficient, so long as the jury is instructed appropriately and presented with adequate verdict forms as to each defendant alleged conduct. Can you please translate that?
In other words, we need proof in here to show that the allegations by either side are correct. So let's see, not saying that they would not be appropriate. In other words, the jury will resolve these issues at this level. It might be something that will be dispositive of the matter on appeal, but at this point, you'll have to put the proof on, and there will be appropriate instructions to the jury. So it's not a matter of just resolution on the pleadings. You have to put on proof. That's standard. Like, for example, you just played this problem with that of him being found guilty of paying hush money to someone to be quiet. New York law requires that the hush money be paid to conceal a crime. So in spite of the defense's repeated request, there was never any proof of what the underlying crime was that was being hushed. The jury was not instructed that that was a requirement of the law, and the whole damn verdict setup is bogus, and it'll be thrown out because of the judge failing to charge the law. So the rule is the jury become judges of the facts and the law under the direction of the court, but the judge of the court is the source of the law. And if the judge gives the jury the wrong law, then the verdict is going to be zip. It's out of there.
Mm-hmm.
So the crucial point is, if somebody pays hush money for it to be a crime, there has to be a crime that is paid to hush. In other words, what crime is being concealed? The answer is there are none. So when there is no crime being concealed or paid to be hushed, and it's simply embarrassment, that becomes blackmail. And from the testimony she gave, it looks like Bragg was threatening to prosecute Stormy Daniels for felony blackmail, and she agreed to testify as she did, such as to escape being prosecuted for blackmail. And there was no underlying crime that was concealed, so while we whoopee.
Right.
There is no case. It's bullshit.
Okay. All right. Listen, Monday, I don't want to go over 2 hours. I would like to end it before the 2 hours because it's Monday. Monday is always a slow news cycle. But I know as far as your availability, that works. It's been working for you. However, a couple of people have been noticing, and they put in the chat, you look tired. Yes, he's been in court all day. That's why he has on a suit and tie. And they also said you look really nice. So he is tired, and I'm tired, but I'm tired from other reasons. But
I got to be back at 9 a.m. in the morning. So
is
there
this
you
your
go.
situation, or are you there for something else?
Situation that is pertinent to this. So anyway, I'm sitting through a good judge, very excellent judge, and an incompetent lawyer on the other side who has no clue what they're up to.
Right. All right. Well,
pathetic, actually.
Thank you, guys. And shout out to everybody that's on X. X is popping. I think I have, how many people watch? I think it's over 400 people on X right now, which is great.
That probably means, other than the shadow blocking on it, probably 4,000. So anyway.
Yeah.
I had a rerun that month before last in a 1 week period had 38 million views. So 34 million views. So yeah, it ramps up, but they don't want you to know that.
All right. So listen, thank you everybody. Let me just shout out my moderators. Love you guys. Southern Belle and Catalia. Love you, love you, love you. Everybody listening, everybody in the chat. And yes, honey, my moderators, they're timing you out now because usually my moderators have been very nice and lenient. Yes, and thank you guys for sometimes you just gotta slow people down. Just gotta slow them down. Just like sometimes I slow the judge down when I have to interrupt just a little tad bit. However, when people want to get to trolling or being slick when they're typing, just gotta slow them down. But thank you so much, everybody, for listening, for tuning in. Of course, we'll be back Thursday. I don't know about the X-Pace tomorrow. I got to see what the judge schedule is like, and he may be extra tired, so we may not even
No, I won't be extra tired. I did this kind of stuff for 50 years every day.
Okay.
So no big deal.
All right. Well, it's tomorrow, and I'm putting 3-minute time on it. And I'm actually going to put 9 to 12. That's it for the X-Pace. So check out the
3 hours.
Yeah. Check out the judge on X. That's at Judge Joe Brown TV. At Judge Joe Brown TV. Get the barbecue sauce. Oh my God. I forgot to upload the video. Let me see if I can still do it, but the outro. All right. Say goodnight, Judge.
All right.
Get some rest.
I don't need the rest. I got some
Yes,
other
you
stuff
do.
to
Like, you
do.
tired. Don't play with me because you're tired.
No,
And you know I can tell you tired when we're doing
this
the show and you
this isn't tired. It's
you
just
actually
focus.
I can see it in your eyes.
Yeah, well, I'm not tired. The bottom line is
Why do you do that? Like, it's okay to be tired.
I'm not tired. What I am more than anything else is pissed off at the way the system works. I saw rank incompetence that was so bad it was offensive today. And I also saw an F up by the judge that had been holding his own down there in Georgia. He'd been doing a fairly decent job, but he blew it. And I'm glad to see this young lawyer stand up like that. And I predict he might be another Johnny Cochran because he's got balls.
Right.
And unlike some of the clowns that are out there in the national spotlight who don't have balls and are afraid to try a case, let alone go to jail for a principle, I respect that.
Right.
I don't think the young man did anything wrong. I think he did what he had to do. And sometimes a lawyer gets caught between a rock and a hard place and he just has to say, lay on Macduff, do your damnedest. That's Shakespeare, by the way.
Tell people where they could go and buy your barbecue sauce.
Okay, you can get this at Judge Joe Brown. The initials are JJB and barbecue, BBQ. JJBBBQ.com. Order some online at our site. We have many products available that are tasty. Or you can go to Amazon, and if you've got Amazon Prime, you get free shipment. And the main thing about recommending Amazon is the shipment's free, whereas if you don't get enough bottles through the website, you'll pay more for the shipment than you will for the product. So go to Amazon, Judge Joe Brown Barbecue, and order it from Amazon and get the free shipment. Now, you have to rush because every month they run out quickly.
Mm-hmm.
And the demand has gone up. We had a block, which was bottles. We had run through the supply of bottles and we had to get an emergency restock in order to deliver the product. But it's good. You probably will say it's the best you've ever had.
Right.
It's good stuff.
It is good stuff. And the link is in the description. Southern Belle's putting it in the chat. So go purchase you the barbecue sauce. It's delicious. I made a brisket today, honey, and I dripped a little bit of the barbecue sauce on it. And yeah, it's good with the barbecue sauce. Yes. My
And
first,
I'll tell you,
it came out good.
and a suggestion on a recipe.
Not
Split it
now.
half.
Can we?
No,
can
just
you
quick.
talk-
Not the. I'm just talking about the sauce. Something you might want to try if you get more than one bottle is mix 1 bottle of the sauce with 1 bottle of malt vinegar or beer, or add 1/3 more beer or malt vinegar. You can take your pick. Make it go further. I like it better that way. Anyway, just a suggestion.
That's a suggestion. I'm trying to, I don't know. I forgot to load something and I'm trying to get it, but I may not even have it in here. Oh, well, forget about it. No outro tonight. Sorry, guys. All right. Good night, everybody. Good night, Judge. Good night.